So now that we are done with what is a contract and what are the essentials of contract, now it's time for us to learn what are the types of contract. So it's important for us to categorize the contracts to have a clear understanding. We have three categories: contracts divided based on the validity or enforceability, based on the formation, based on the performance. Validity or enforceability, formation or performance are the three groups into which the contracts are divided. Now we will see our first group, which are the contracts which are divided based on the validity. The first thing is valid contract, which is pretty simple. An agreement which is binding and enforceable is a valid contract. An agreement is binding, and binding is nothing but it has got that element of enforceability, which is both the parties are bound by their rights and duties. So that is binding. So an agreement is binding and enforceable. An agreement would be enforceable only if it contains all essential elements of a valid contract. Now it's time for you to pause the video and recollect the essential elements that we have learned earlier. Okay, just recollect what are the essential elements of a valid contract. Now, the next category is the void contract. Void contract is nothing but section 2 subsection J gives us the definition of void contract. Try remembering sections but do not stress or spend much time. It's totally fine. Just if you can recollect, that's really 2 subsection J gives void contract, a contract which ceases to be enforceable by law, which which is stopped to be enforceable by law. It is no more enforceable. I mean, no party can sue the other. It's just done. Okay, then that contract is a void contract. It ceases to be enforceable by law. When it becomes void, it obviously there's no enforceability element in there. Okay, if you see, the contract definition is agreement enforceable by law. When there is no enforceability, then it is not a contract as such. It becomes void. Okay, is one, it cannot be enforced. Examples here we have very good examples. That is, for the first example is X promises to write a book. Okay, X promises to write a book, but X dies in an accident. Here, the essential one of the essential elements for to be a valid contract is the performance. Now that X is died, the performance element is missing. Who will be performing this contract? So upon X death, the contract becomes void. That is, no party can sue others saying that the contract is not done. Okay, so the performance element is missing. The contract has become void. And then the second example is A promises to sell 10 tons of sugar to B, but then factory of A gets fired and all the sugar is got fired. So the performance element is again missing in here. No party can sue the other saying that you did not perform the contract. Now B cannot sue A. The moment the factory is caught fire, the performance element, the possibility of performance is missing there. So the contract becomes void, not enforceable anymore. Okay, done with learning what is valid and void contract. Now the third category is the voidable contract. Voidable contract, the moment you hear this term voidable contract, you should be able to recollect our pick. A contract is voidable when it is signed by misrepresentation. Example for misrepresentation is a person says that 10 years experience person is going to construct this building, but in reality, no experience or less experienced person is constructing. In that case, contract is voidable. Coercion is again the pressure. Undue influence is influencing or blackmailing. Okay, that is undue influence. And fraud. When a party gets contract signed by exercising these things, then suppose A has exercised all this, put all this pressure or threatening on B. Now, if B can go to court of law and sue A saying that I'm not going to perform this contract because you have threatened me to sign the contract. B has got every right of doing that, saying that I won't perform this contract anymore. But A can't go to court of law because he is the person who threatened B to get the contract signed. He can't go to court of law and sue B for not performing the contract. A has got no rights here. B has got right of not performing the contract. Okay. Now if you read the definition, that will give you more. Section 2 subsection I gives voidable contract definition. 2 subsection J gives void contract. What is 2 subsection I saying? An agreement which is enforceable by law. The moment you listen this term enforceable by law, you should recollect suing in the court of law. Enforceable means the part enforceable by law is when one party goes to the court and sue, then law permits that. Okay. An agreement which is enforceable by law at the option of one or more parties. Option of one or more parties. B is that one party over here, but not at the option of the others. If you see A, at his option, that contract is not enforceable. If A goes to the court, court will not even look at his that petition. Okay. It is not enforceable at the option of other party, but enforceable at the option of one party. Usually the party who threatens will not have any rights in a voidable contract. Who got threatened can cancel the contract. So that is the voidable contract. It is enforceable by law at the option of one or other parties, but not at the option of the other party. Only one party has got right to enforce that. Okay. So recollect voidable is this presentation coercion undue influence and fraud. That is a voidable contract.